Zoom. So I do not know. I hope because this is a very
Good afternoon. Good afternoon, all present here. All
very good.
human, all human beings are born free and equal in dignity and rights. They are endowed with reason and conscience and should act towards one another in a spirit of brotherhood. I, Dr. Sadaf Khan, on behalf of the entire Faculty of Law, welcome you all in this 14 days International Faculty Development Program on changing paradigms of human rights in a globalized world. The 12th technical session of the FDP is dealing with the role of international organization in protecting human rights. Many organizations around the world dedicate their efforts to protect human rights and eliminate its abuses. Major human rights organizations maintain extensive websites documenting violations and calling for remedial action, both at a governmental and grassroots level. Public support and condemnation of abuses is important to their success, as human rights organizations are most effective when they call for reform are backed by strong public advocacy. To deal with this matter, we have our Honorable Resource Person, Dr. Ravindra Pratap, Dean Faculty of Legal Studies, South Asian University. Sir has completed his PhD from Jawaharlal Nehru University in 2002. Postgraduate courses in international trade law jointly from the University Institute of European Studies, University of Turin, UN Citral, and UN Detroit, and ILO in 2000. He did LLM in European Business Law jointly from the Universities of Barcelona and LUISS Guido Carli, Rome in 1999 and MPhil in Legal Studies from Jawaharlal Nehru University in 1998, MA in Political Science with International Law from Allahabad University in 1995 and LLB from Allahabad University in 1991. Sir has more than 20 publications in reputed international journals and his area of research interest are international law, international trade law, transitional litigation, and legal interpretation. Welcome, sir. Enlighten us with your thought provoking session. Welcome, sir. Over to you, sir.
Thank you. Thank you very much, Dr. Khan, for a very kind introduction that inspectors that you have given of international law and of the significance of human rights. To the audience, I had been briefed in the morning that there are approximately 150 of those, 120 are having a law background, so that would be a wonderful thing for me to converse with. So my talk is broadly divided into three parts. So what I hope to do with the people is that to first briefly touch upon international organization, just to give a small introduction, because many of you may not have had the opportunity of studying this specialized form of international law, the organizations, and then perhaps to descend to introducing a bit of some little time on human rights, and then to come to the main, the body of my, discussion, that is the action through the United Nations, which I should be focusing because of the very comprehensive nature of the United Nations, including in the field of in human rights and many a treaty body that it oversees through its varied institutional mechanism. Now, having said that, let me start with the idea of why do we think that we need international organization? And the idea is, if you just go back to a very important event in 2011, and one might ask a question then as to why did the United States move to the Security Council after 9/11? Now you might wonder, you see, that the most powerful country in the world decided to approach the United Nations. Why did it not do what it eventually did before and without approaching the Security Council? And when we speak of Security Council, we ultimately speak of an international organization. This is a very important question. Or we might, you see, ask a different question, that why did, you see, 113 countries in 1995 sign the World Trade Organization agreement? I mean, they all are traders. They did not produce anything with the any international organization. The question then is, why did they do so? Which is very important for us. I'm trying to, you see, provoke your thought process, that deliberately asking these questions, so that you should be tuned to the theme and the institutional structure within which we are going to discuss briefly human rights. Or, for instance, we might also ask ourselves, why did the United Nations itself send its human rights, or you say, mission to Nepal in 2007? That is also a very important question, because one might say that it was an affair which was internal to Nepal's human rights. Why did United Nations go there? And if it did go, as it has, was it constitutive of any form of intervention? Or whether it was some kind of a facilitation in transition to normalcy after a long drawn out civil war in Nepal? We may also ask, you see, yet another question to ourselves, that why did the Security Council send its mission to Bangladesh in 1971? Because, as you know, 71 is the date, you see, is the year in which Bangladesh got independence. And Bangladesh independence was not brought about before or without a significant level of mass atrocities, human rights violations. So that is another very thought provoking, you see, question for conditioning our thinking before we descend to details for discussing the role of, you see, united or international organizations. We might still ask another question, that why did the Security Council send its mission to India and Pakistan in 1948? As you know, 1948 was the year that followed the year of 1947, which had witnessed not merely finally the division of the subcontinent into two nations, but also had preceded an untold human rights violations? Which is very important question, very thought-provoking question. Now, all these questions, if we combine all these questions, it is possible for us to draw some very broad common themes in each of these questions. And that theme is a functional centralization by international organization. The core idea of international organization is to centralize, synergize functionality of many contributing agencies, actors, and of which most important are and would remain in the foreseeable future the states. And that is what explains that the United States went to Security Council UN because United States knew very well that there was no other entity than the United Nations readily equipped with infrastructure, institutions to deal with the situation that it had faced. It was also very important for the United States to notice that going to the international institution and succeeding in getting it take a reaction against, you see, the perpetrators of terrorism would have much greater chance of legitimacy of action than would be the case were it to go alone. So, in other words, this is the most important theme, you see. Now, the theme of functionalism, as we could see, could be traced to the writing of one of the finest international organization theorist, Professor David Mitrani, and in that to his celebrated work, what is called a working peace system. The idea in that working peace system was that it wasn't enough that in 1945, of course, I'm talking of the last such development which followed the end of the Second World War, to establish an entity which should be called an international organization. But it is also very important that the entity should be able to work, to function. And that was basically the theme of Professor Mitrani's thesis of functionalism. He noted that it is very important that an organization should not merely be established, but must also be equipped with all necessaries that it requires to be able to function, because as he saw at that point of time, the world, as you know, after you see the end of the Second World War, and no sooner was United Nations established than the world started witnessing the emergence of a Cold War. And when Mitrani was writing, he saw this picture of the world, then how would it function? Because the world is already divided into competing, what he called competing political units. And these competing political units he identified at the root of international conflict, because there is a disregard for the constitutions, agreements, and as you see, even after the end of the First World War, there were several pacts which were signed, but the states did not respect, and the world had to degenerate very soon into another world war. So Mitrani was, you see, invoking these very important developments and these particular phenomena where you do not have regard to pacts, agreements, constitutions, then this works against the establishment of some kind of a federal world government. And that is why Mitrani said, forget about the possibilities. There's no point in wasting time to have a world government because the states, the most important constituent instruments, would not cede to any such conceivable entity the kind of legal competence and autonomy which it requires to function as an independent government at the world level. Now, how do you do it? So, Mitrani said that is not the attainable objective. The attainable objective is to be able to establish a system which functions. Now, how do you know the functions of an organization? That is another, you see, question. In order to be able to identify with a certain degree of definitiveness the functions of an organization, one has to refer to the constituent instrument of the organization. And when we speak to our students, how do you establish international organization? Then we say international organizations are established by a treaty. Now, this treaty, if you look at any treaty which has established any international organization, of course, I have not seen all treaties, but some treaties which I have seen would inform me that there would be no international organization which a treaty has established without delineating its functions. Now, this functionalism is deeply embedded in the constituent instrument of any international organization. And this fact itself, this feature itself, is of far-reaching consequences for any endeavor of the organization. Because whenever you assess the effectiveness, whenever you assess the role of organization, reference would inevitably be made to the functions of the organization. The second important facet of international organization is that even if you have established functions, now please try to understand how would it function independently of the countries which have established it. And there comes another beautiful juridical idea. And that idea is these treaties, in most cases, I don't want to get into further details about, you see, these means constituent instruments. But what I can tell you with certain degree of, you see, satisfaction and generality is that there is a conferment by treaty, some measure of legal personality to organization. Now, this separate legal personality of international organization is the irreducible juridical fulfillment for the organization, for the advancement of or furtherance of its functions. Now, having said that, you see, I should tell you very briefly organization. So, as I told you, and this is the organization that I'm going to focus, you see, in my substantive, you see, talk, and that is the United Nations Organization. Then you have World Bank, then you have International Monetary Fund, you have European Union, which is a very important regional organization. You have an organization in the field of trade, that's World Trade Organization. You have another, you see, regional organization that's called NATO. You must have heard of it or its activities in the close neighborhood. It's Afghanistan for a long time. Then you have, you see, these entities. Now you could see that this is a short, you see, introduction to the uh, the international organization. Now, having said that, we should get into, you see, how human rights, you see, relate to international organizations and to especially to the United Nations, on which I'm going to focus on. If you see the preamble of the United Nations Charter, you would find that human rights is a very important reference in the, the Charter of the United Nations, which you see, which talk about uh, you know the functions of the United Nations, and out of these functions, what you can see, the one of the very important functions of the United Nations, and in fact, that is a function, you see, that relates to the very irreducible nature of the United Nations. Now you can see that the very second preambular paragraph of the United Nations clearly states its faith in fundamental human rights. When United Nations, just as the Constitution of India, established in the name of the peoples, so is the United Nations. Please note it very carefully that although the organization is established by states, but the name in which the organization define itself, role, functions, is the peoples. We, the peoples of the United Nations, determined to reaffirm, the peoples of the United Nations have determined their reaffirmation, faith in fundamental human rights, in the dignity and worth of human person, in the equal rights of men and women and all nations, whether they are big or whether they are small. And look at how it proceeds further. You see, it also talks about that in order to move on these functions, including the function of human rights, the the most important, you see, the purpose of the United Nations, which being to be able to establish and maintain international peace, and also, you see, to achieve international cooperation. And this is very important for students and our colleagues to note respect for human rights and fundamental freedom. So what you can see that the name in which the organization is established are the people. Recitals in the preamble addressing to reaffirm faith, the purpose 3 of the United Nations, clearly reproducing the uh, respect for human right and fundamental freedoms. And then there are, you see, principles by which the United Nations has, established itself with the purpose of protection of human rights. Now, having said that, I think it is important to just devote 5 or 10 minutes, at least 5 minutes, to talk about how human rights have emerged, you see, in political theory. Now, human rights have, you see, emerged in political theory in at least 2 ways. First, as defensive assertions against the state's action, and then you can see as positive claims on government to satisfy human needs, which means liberty, limitations of liberty. Now, the human rights in political sense as liberties, which are rights as liberties. And if you see in the Wesley's and Hofford's, you see classifications of fundamental legal conceptions of 1919. Now, there are no correlatives duties because rights as liberties, there are no correlative duties. And the second is the positive claims on government to satisfy human needs, which means there are limitations on liberties. Now, if you see this categorization of human rights into positive claims, you would also notice after the United Nations Charter, Preamble, Universal Declaration of Human Rights of 1948, the 1966, and that is the path breaking development in the role of the United Nations in the promotion and protection of human rights was the signing by states of the Covenant on civil and political rights. And we call it in the sense of in the terminology of human rights, the the rights which are termed as rights of first generation or means first generation of human rights which are of civil and political nature. The second, you see, in the second category of positive claims on government to satisfy human needs and in terms of limitations on liberty are socio-economic rights. Now, on socio-economic rights also, we have, you see, the 1966 International Covenant, and we call these rights as the second generation of human. Then you have a third category where you can see there are, you see, rights which belong not to an individual but to a group. So we have, you see, in this category, what we call group rights. Now we call these group rights as, you see, the human rights of third generation. And if you might recall, you see some of the illustrations of this category of group rights, you might uh, you see offhand would for sure include the right of self-determination, and which is, as you know, one of the most, you see, critical of human rights of entities which are comprised of individuals. And then you also have in a cognate category of a third generation, like for instance, of a particular stage of the human development, that's called the rights of the child. Now, if we move on to the gender and try and find out the rights concerning, you see, groups, well, you can well categorize into the rights of women, or we can also include the rights of migrant workers. And finally, we can also, you see, speak of the right to development. Now, having said that, you see, the political, in the political formulation, conceptualization in human rights. Now, what do you have to see? You see, next is how do these human rights become a legal reality? In order for human rights to become a legal reality, in other words, a transition from political theorization of rights, political, you see, in terms of political claims, assertions, and claims into a legal reality, the first condition that needs to be satisfied is the existence of a de jure state. In other words, a state which on the international plane would exist provided certain conditions, as are stated in the Montevideo Convention, are satisfied. But in terms of internal, you see, constitution, there must exist a de jure state. Now, this de jure state, how do we determine that there does exist a de jure state? And this is established upon the right of self determination exercised in one of the three ways. First is the emergence as a sovereign independent state. Now, this concept of sovereignty is a very important functional attribute of statehood, because in the organization that is called the United Nations, this is the first functional principle of United Nations. Sovereign equality of states, which means juridical equality, which means formal equality, which does not mean, on the contrary, material equality. So, so the first condition being that there must emerge a sovereign independent states. Now, how do you know that there is independence, and how is independence related to sovereignty? Now, this is on an international plane a very important, very significant thing to understand. Now, if you recall a very famous case which Professor Max Huber, as arbitrator, decided between the Netherlands and the United States, if I correctly remember, sometimes in 1928, the island of Palmer's case, where international Professor Hoover defined sovereignty in terms of independence. And I quote what he said was that sovereignty in relation to states implies independence, and independence in relation to that part of the globe is to exercise therein the functions of a state. Now, what you can see is significant in the formulation of Max Huber was the concept of functionality relative to the concept of independence, which in turn is explained in terms of sovereignty. So please try to understand the irreducible core of sovereignty is independence. If you are dependent, then please note it categorically that you are not sovereign. Sovereignty minus independence is nothing but extinguishment of sovereignty itself. Put it conversely, if independence is compromised by an exercise of sovereignty, even if independence is gone, there remains sovereignty, which is very important to remember because students recurrently ask this question. This international agreement imposes these restrictions on sovereignty. Of course, if you sign agreement, so what you forego is what is gained by the other party, and what is foregone by the other party is gained by you. So, in other words, there can be no agreement without some foregoing for one and some foregoing for the other. So, in other words, there is an incidence of sovereignty, which is a logical corollary of the result of an international agreement. But the question is this: how does sovereignty survive? And the answer is foregoing of independence by consent, by exercise of sovereignty, and not without it. So the question for sovereignty is not whether independence remains, much less whether how much it remains. The question is whether independence is foregone, whether independence is diminuted with consent or without consent. And that is basically the hallmark of, you see, the relationship between sovereignty and independence. The second is free association with independent state. That is also the second very important consequence of the right of self determination, which would determine whether or not there exists a state which is a judicial state. And the third is integration with an independent state. Now, the peoples who have exercised the rights of self determination, if they've not been able to integrate, then obviously there would be infirmities of one or more identifiable degrees in the exercise of the right of self determination of people, and that you find in many states. You see that the status is on a formal plane. You see sovereign, and yet you find some people not integrated with the state that follows the exercise of right of self-determination. The second important, you see, element for human rights to become a legal reality is the governance by rule of law. Now, as you know, rule of law is a very important concept. It continues to be, you see, manifest in several ways, and there are, you see, lots of, you see, discussions in political theory and also legal. So from the time of dices, rule of law, to the time of United Nations and its relation
to human rights, the irreducible core of rule of law is that it is the law that will rule. It is the law which will be the arbiter. If the question is this, how the law would come? The law would be the result in relation to human rights, is basically the consequence of the exercise of the right of self determination. But once that law has come, then it is you would not go back to the self determination. Then otherwise it would be a complete nonsense. It is basically the rule, it is the law that will decide. And that is what you can see, that when one person goes to a court and files a PIL and the PIL is allowed, you see, what is the result? One person succeeds in securing a judgment against hundreds of people. If it were not for rule of law, if it were for democracy, then you could say, how can one person decide, you see, the fate of 100 people? Or you might even say, how can two judges decide what is good for 200 people? And the answer is, it is not two judges. It is a blinkered view to see two men, you see, giving the judgment as two. The legal view is, it is the law. So it doesn't matter. It doesn't matter whether law is pronounced by one, 200, or 200. It is the law. It is the rule of law. So that is basically the very important. In other words, men will not decide. The number will not decide. Once law is sourced from exercise of self-determination, then you will not go back to self-determination. To go back to self-determination would be to annihilate, to de-recognize the outcome of the exercise of self-determination. So in other words, once self determination has been exercised, then it will be the governance by the rule of law, which is the outcome of the exercise of the right of self determination. The second concept you see in human rights as a legal reality is the existence of a specific legal framework. Now, if you do not have a specific legal framework, it would be very difficult for the idea of human rights to function. Now, the first condition, first necessity for having a specific legal framework is the creation of a legal system for their protection. The second is the grounds on which the creation of a legal system is established, which means the right to work, for instance, from the point of view of creation of a legal system, to permission to die of hunger unless the state also creates conditions conducive to its exercise. Similarly, the grounds on which the creation of a legal system is to safeguard the human rights of others, for instance, the life of the group and the life of the humankind. The third important ingredient in order for human rights to become a reality are, you see, effective guarantees. How do you protect it? You say on paper that you have a right to do this and this, but if it is infracted, violated, derogated from, then what do you do? And like for instance, with reference to the Constitution of India, you are aware that you see you have Article 226 and 32. You see in the Constitution that you can move to court for protection of human rights. So this is something very important. And as you could also see in the political system of Hobbes, the right to resist, or American independence, declaration of independence, so French Revolution, building public opinion, or you see teaching, training, and informing. Now, this you see ends my second part of the discussion with human rights. So, see how from the conceptualization of international organization, what is international organization introducively is, then how human rights become a reality. Now, to link between the two is the action through the United Nations for the protection of human rights. Now, before the United Nations, what you can see, the individual were seen mostly as aliens and not, you see, nationals, not as an individual. Please try to notice there's a very subtle but significant difference. Individuals as either aliens or nationals. It means either you belong to a country or you belong to none. In other words, there is no third category. Put it otherwise, if you belong to no state, which means you have no means of protection. Why? Because you have no identity. So your identity is relative to state. And now the consequence of this war being in history that there have been excesses by the states. Why? Because individuals had no recognizable existence vis-a-vis states, and therefore they had suffered. You can't believe it. There used to be a time when people were sold. We know this history of slavery. Or an emperor would decide, you see, that you go and wage war. Why? Because he wants to settle a dispute with one of its neighbors. It doesn't matter whether it is right or wrong, or to order that you go and capture territory. You have no entity. You could be bought, you could be sold. The consequence of United Nations, and this is the first very important thing that we should notice, is the recognition of individuals independently, at least in substantive terms. I am aware of, you see, enforcement limitations that we will see later. But this itself was no mean an achievement of the United Nations for the individuals to be liberated for their substantive recognition from the framework, or if I should say more curtly, clutches of states, means as an individual. The second important, you see, part of the action from the United Nations for the protection of human rights are two provisions in Articles 55 and 56, which are actually articles in the Charter of the United Nations, the how um, secure, what is this, international economic and social cooperation would function within the United Nations organization. And what it talks about, Article 55, is to create the conditions of stability and for the well-being of people, which it believes to be necessary for the overall purpose of the United Nations, that is the peaceful and friendly relations between the nations. And the United Nations shall promote, you see, higher standards of living. So, in other words, as we were talking about sometimes before, after the preamble, and purposes, the actual articulation of how United Nations is going to protect human rights could be found in Article 55, which talks about higher standard of living, full employment, and conditions of economic and social progress and development. This is a very important formulation. Now, it also talks about, you see, solutions to international economic, social, and health and related problems, and cultural and educational cooperation. So, in other words, human rights were conceived in a very, very broad framework. Then, finally, it also talks about, you see, the universal respect for an observance of human rights and fundamental freedoms. Now, this is typical of the language that you may readily find in the articulation of formulation of the Universal Declaration. Now, this is basically the so Article 55 is actually a substantive statement on, or I should say, at the most, at the highest possible normative level, you see, where United Nations has stated the scope of its protection, its role in the domain of human rights. Article 56 is basically a commitment, you see, between themselves, and also a pledge to the organization itself to take action, basically, whether the action is taken between the state themselves, or between a state or a group of a state on the one hand, and the organization on the other, for the ends, as I just, you see, referred to in Article 55, for the purposes, which are stated in Article 55. So this is how, what the scheme of now. Let us descend to see some of the institutions which have been established within the United Nations. So first, you have a commission, you see, which is was established, you see, by the Economic and Social Council in Article 68, and with three very important, you see, functions. One is the functions which would set the standards, which means those standards which not be the functional articulation of human rights. For instance, the Universal Declaration of Human Rights, so which is a standard setting, you see, instrument. Then you have promotional activities, for instance, advisory services, technical cooperation, or seminar fellowship, all that. And third is the monitoring and assessment, which is very important. This is the real, fulcrum of the commission, and which is also very important from the standpoints of treaties, treaty-based procedures, or charter-based procedures for the implementation and monitoring of human rights bodies and instruments. Now, the second thing that you notice is that each of these human rights treaties, covenant, or rights of migrants workers, or rights of child, or anti-discrimination, or whatever, all these, has a human right committee. Now, this committee is independently of the commission. The purpose of this committee is to basically oversee the the working of the each of these human rights treaty bodies. Then you have some special procedures, which are country specific procedures. For instance, the procedures for one procedure, which you might recall, is a procedure which Economic and Social Council had established in by its resolution 1235, and it is mandated by the Commission under the Charter. The fourth is the subcommission, which is the commission subcommission, and which is basically to focus on more specific aspects of promotion and protection of human rights. For instance, which is a more compact body. In fact, this is where the real functions, what you can see, and as the academics, you could see that this is basically the intellectual hub of the human rights work, apart from the committees, and that you have experts from all over the world. You see, part of the subcommission of the Commission on Human Rights. Then you have you see more pointed functioning of the human right, which means that you identify a particular theme, and then on a particular theme, we 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 established a working group and special procedures and reporters, in fact, who would collate, collaborate, and coordinate the work of experts in those working groups. Now, for instance, if you like, for instance, the working group of on 1918 working group on enforced and on involuntary disappearances and on arbitrary detention. So, in other words, you see, so what you see from the top to down is that there is, it's like, the deeper you go, a more specific, a more task oriented an institution that you have to, establish. Then in 1993, that we had a human rights, United Nations Human Rights High Commissioner on Human Rights after the Vienna Conference on Human Rights. So this is another very important institutional development. From the standpoint of international organizations in the field of protection of human rights. Then you have these very important treaties, and one or two, I have already specified. For instance, International Covenants of Political Rights, 1966, Economic, Social, and Cultural Rights, 66, and racial discrimination. So you could see that 1966 was perhaps the most important year. One single year for the a very concrete, because as you know, treaties are the most important and highest normative form of lawmaking at the international level, and you could compare treaties with legislation on the municipal plane. So you had three conventions, adopted in the year of 1966. Then then there is another development, that took place in the 70s. In the 1970s, 1979 should be noted, from must be credited, to the United Nations role in the protection of human rights, because that year saw the convention, an elimination of discrimination against women. It's a path breaking, development. So the 70s was the decade where the gender received, you see, the highest level of importance from the international organization, that's the United Nations for the protection of human rights. Of course, you can see the functioning of a CEDAW, lots of you see developments, specifically you see in countries like Bangladesh or Sri Lanka, where you can see, if you are interested, you see, in getting to see uh, the functioning of CEDAW. But nevertheless, that is the most important contribution. Now, coming to the 80s, I must, you see, say that 1989 was the most important year that must be credited to the work of the United Nations as international organizations in the field of human rights protection and promotion. That is the adoption of Convention on Rights on the rights of child. The 90s was another very important year where rights of migrant workers convention, you see, was signed, adopted. So these are very important, some of the path-breaking developments, and in terms of legal consequences, normativity are the highest, you see, forms in which the United Nations has worked in itself. Could you please tell me how much time that I have still to speak on? Not, I do not know, because I can wind up in 10 minutes and I can, you see, go on for hours. So I should know the time that you have given. I should have asked this question in the beginning. Nevertheless, you can tell me now. It is already 5 past 2.
So you can sum up in next 10 minutes.
Okay, fantastic. That would be perfect. Now, so if you see these treaties bodies, these are, you see, these treaties bodies would discernibly, you see, underscored significantly the conventionalized form of underlying international human rights norms and their institutionalization. So this is a very important, you see, development. And then in the 2020, you review of these treaty bodies as mandated by the United Nations General Assembly resolution of 2014, you can see there are several administrative changes, capacity concerns, and resource constraints which were identified and which were very importantly taken to go. Now, finally, there is this 1973, um, development in the field of genocide and refugees. Now, there are linkages. Of course, the genocide was a field which had occupied the scene from 1948 onwards, and also of the refugees since 1973. Now, 1951, and subsequently apartheid conventions from 1973 onwards. The difference is this, that these instruments, they do not provide for a reporting mechanism. Now, in the most recent, you see, case of the issue of the rights of the Rohingya people, which you must have noted, not merely in this country and especially in the judgment of the Supreme Court of India very recently, but also on the international plane by two very important developments. One is at the political level by the United Nations, constituting United Nations independent fact-finding mission on Myanmar to see to assess the facts on the ground as to what has happened to Rohingya, and you can see the two reports which this commission had submitted in 2018 and 19. One of first was, I think, a very comprehensive report of more than 400 pages, and conclusively documented the atrocities perpetrated against the Rohingya people. And the second is the development, which I should take a little extended view of United Nations and include, and I should include, because International Court of Justice is not merely a judicial organ, but also a principal organ of the United Nations, and in that category would for sure qualify for its role, which, if it is significant, as it sounds to me to be the case in this Rohingya case, the issue, and last year when the ICJ indicated, you see, provisional measures for protection of the rights of the Rohingya people. Now, I think this is all that I wanted to, you see, talk about. Now, to sum up, you see, in one or two sentences, the role of international organization, you can see, has transited, you see, from the time especially from 1945. Initially, the role was more of a hortatory kind, in the sense merely the treaties providing goals and functions. Then it shifted towards little standard setting. The third phase was actually the instrumentalization of the human rights. And the fourth phase, I could say that, a more functional role. And now the fifth phase in which we are living, I should say, in the 20th century, where I could say that you could see a concrete, forms in which, I'm not saying that in all areas, but at least there are areas in which this development could be discerned, and hopefully the role of the United Nations and would find its concrete culmination for the protection of human rights in the world. Thank you very much.
Thank you, sir. Thank you for your enlightened words. So now the session is open for the question and answer. Shall I ask the question, sir?
Yes, please.
Sir, our participant Masood Ahmed from Murshidabad asking, why do states resist international scrutiny of their compliance with their duties to promote and protect human rights under the Charter?
Yes, I can read this question. You see,
Yes,
the
sir.
difficulty is this because, as I told you earlier, the most problematic thing is the sovereignty. The problem is this because states believe that the sovereignty is something which should be proudly states should be proudly possessive of. Now, which is a very archaic. There is nothing which should be proud of in terms of possession unless what you possess has a role to be proud of. Now, if you sovereignty is not basically a title of conferment, it has a functional role. So, if I should say very curtly, without getting into details, I should be saying that the states clinging to an outdated conception of a sovereignty, and that is why they are refusing. That is the one side of the story. The second side of the story is that they may well have legitimate concerns, and in the light of monitoring of human rights situation in the states, it is quite possible that what is termed as monitoring is veiled or also is complemented by some measure of intervention in internal affairs of a state, which of course is not permitted.
Thank you, sir. Next question from Vinita Chaudhary, and she's asking, what if any big power in the world like China or
I will read this question. What will be the possible approaches to establish a legal link? I the first part of the question, I think the slide. What what if any big power in the world like China or Russia fail to comply with the human rights standards? Is there any possible make them comply with the rules? A very good question. You see that Vinita is asking. The problem is this, as you know, uh, on international plane, and I should say, is not substantially different from what it is on the municipal plane. Is basically how to secure compliance from where the compliance is most difficult to secure, and that is powerful states. And when we see China, as you said, and Russia, you know it very well, these two states are more than one equal because they happen to be permanent members. The problem is this: how do you secure compliance if they themselves do not want it? So it's basically not in terms of their juridical accountability, but it is basically the executable capacity of that accountability against the permanent members of the Security Council, because it is the very Security Council which is the ultimate enforcer on the international plane. And if you have to secure accountability against the very members of the Security Council, and then you go to this square one situation, then how could you have the same body taking action against itself? But in principle, uh, there shouldn't be any problem. But the problem is this, as you know, the biggest and recurrent challenger to law, and that is was and probably, but unfortunately will remain, is power. And power is that candidate which the law finds most difficult to confront. There is no other candidate against which the law is really, find its most serious problem. It succeeds, but it doesn't matter that it doesn't cease to be a challenger. And when you see on the international plane, I think the Security Council paradigm is the best to underscore this point. Then there is a question: what will be the
yes, sir. Yes, sir.
possible approaches to establish a legal link between international organizations and their members human rights treaty
Duty or
obligations.
obligations.
Yeah, legal link between the international organizations and their members. You see, uh, very good question, and a very good question from a research, point of view. Now, if you see the link, as I told you in the beginning, the link that on which the United Nations system itself is, to my mind, and quite prophetically, as Professor Mitrani had to say, the functional link between the two. Other links could be what are the themes of human rights treaties transiting from the time of the more first generation of human rights, like civil and political, to the more, you see, third generational, or you may be the fourth generation human rights. So there could be two. One is from the
the central unifocal approach traced in the very idea of the international organization, and link that approach to the members of human rights treaty members human rights treaties obligation, which means the states. The second is to link you see them to the along varying um, scope, nature, and scope of United Nations, treaties on human rights. That could be, or basically, or the third possible approach could be, which you can see from the very enforcement structure of human rights. Treaty bodies is basically the working groups approach, which means the theme itself, or for instance, like uh, for instance issue specific linkages, for instance like Rohingya issue, for instance. So you pick up a particular approach, and that would be, you see, I would say, the more of an empirical sort of a work. So in other words, two more doctrinal approaches would be first two would be more doctrinal one, and the third would be an empirical you see approach that you could use as a link between the two.
Thank you, sir. Now, the next question.
How do international norms independently impact the advancement of human rights? You see, Masood, what you need to see the impact of norms on rights are actually how they make a difference to those entities to which these rights belong. Now, what you are asking this question ultimately, and as if I correctly understand, is basically the implementation aspect human rights. Now, as I told you, when I was, if you could just recall my second part of, and that is where, knowing that my topic is entirely international, but I did deliberately, you see, discuss the second part because I knew that, if you simply talk of human rights on international plane, the moment a student, you see, asks you a question about implementation, so you have no orientation, no answer to this. So it is the second part. You see, how do you make human rights a reality? And as I told you, the 3 points. The first is the existence of a de jure state. You see, and the third point was, if you remember, effective guarantees. So it is basically through effective guarantees could international human rights norms, you see, make an impact on the advancement of human rights. That is my first part of the question, and which I should say mostly the case. In a minority of cases, there is a possibility of making an impact where some optional procedures in the human international human rights norms, which, if accepted by states and allowed, you see, and invoked, availed of by individuals, and in those cases, that could make a difference. Like optional procedure, you see, in the civil and political rights and the work of the United Nations Human Rights Committee. Or if you are more interested in extended, you see, field in which, if you want to talk, the work of the Inter-American system on human rights, and I should say very important after the work of the United Nations. So the third would be, I should say, the work of this is Strasbourg system, that is the European Convention, the functioning of the European Convention on human rights. So on international plane, you have only a very minority of situations where it could happen. But if you go to the regional level, and there I should give you two examples, that is the inter-American one and the European one. There you can see a very significant, almost regular feature how these norms impact the advancement of human rights.
Thank you, sir. Very informative session, sir. Now, I would like to invite Ms. Shipra Mishra to address the vote of thanks. Over to
Thank you,
you.
Sadaf ma'am. Thank you. A very good afternoon to all of you. I, Shipra Mishra, on behalf of the entire Faculty of Law Integral University, would like to express my pleasure to deliver the vote of thanks for today's session. With profound privilege, I would like to record my sincere appreciation to Dr. Ravindra Pratap Sir, Dean, Faculty of Legal Studies, South Asian University, Delhi, for giving us time from his busy schedule and discussed with us the establishment and working of international organizations, the role of international organizations in protecting human rights with the help of conventions and treaties, their functioning, and determination in working for We the People's International. I hope that everyone present here will have a lot to take away from your inspiring and thought provoking words. Lastly, I also want to thank all the participants from different universities and colleges for joining us virtually and participating actively in the session. Thank you all. To conclude, let me once again reiterate my gratitude to you, sir. Thank you, sir, for virtually addressing us. Thank you.
Thank you very much, Shupra, for your very kind words, and it is indeed a pleasure. And that is what I
Thank you, sir.
always say we teachers are good for. We have inherited more from our teachers than we could possibly, you see, transfer to our, you see, juniors and you see, colleagues. So I'm very delighted, and I wish you all the best in terms of your individual's
Thank you so
endeavor,
much, sir. Thank
and
you.
also to the institution, the new international university, which I've of lately. See, one of my students told me, I said I should definitely accept, and I would really, because if you were invited me to physically travel to Lucknow, which is I would, it would be impossible for me to leave Delhi. But yes, I think there are some good, consequences of adversities like COVID, that we are able
Yes.
to reach to those people which we could really never go. Thank you very much.
Thank
All
you
the
Thank
so
you.
much,
best.
sir.
Thank you, sir.
Thank you, sir.